Welcome back to Sunrise. Joining us this morning is our lead counsel on employment and labor laws, Jonathan Morgan, partner at DunnCox Attorneys at Law. Now, the Sunrise viewer question this morning is, my name is Mercedes, and my company called me into a meeting to tell me that my position was being terminated because they found artificial intelligence that can do my job instead. Is it okay for my boss to fire me on the spot just to replace me with some fancy software? Well, I would say, what does your contract say? What would you say?
Well, the contract is the starting point in relation to the terms of employment and the terms at which they can be terminated.
Separation, yeah.
But it's just the starting point. The law goes deeper than that, and the legislation has mandatory notice requirements that must also be followed by employers. So if an employee is working for an entity for, let's say, 1 to 4 years, the requirement is that they be provided with 2 weeks' notice before they are terminated. But this particular question...
Even if a clause in your contract says you can be terminated on the spot?
Correct, certainly. So the contract is not capable of deviating from what the legislation says.
So the contract saying that is not legal because that's not what our labor laws speak to.
That's correct. So the contractual clause itself, allowing for instant termination, would be considered an illegal clause, and it would be void ab initio. And the reality is that the law provision that provides for at least 2 weeks' notice must be followed.
I thought that the general rule of thumb is that your notice tends to be in line with how you get paid. So if you're a fortnightly worker, you tend to have on both sides, because when people are saying, I'm going to leave my job and then just resign and leave, and I say, yeah, but you can't do that. Are you paid monthly? Well, then you should give a month's notice. Are you paid fortnightly? Then you should give 2 weeks' notice. I mean, that was a norm that I was exposed to some years ago, but you're saying that that's not necessarily in law.
Not quite. That type of notice period relating to the period of payment may arise in other situations. Landlord and tenant come to mind, for example. But in the employment setting, the legislation prescribes the notice rate. And it says that if you have been employed to the entity for under a certain window of time, you're entitled to 2 weeks' notice. If you are employed for longer than that period, let's say it goes across 4 years and into 5 years, the period of notice required is extended to 4 weeks, and it increases accordingly.
I did notice in the initial response, you mentioned a very specific time frame, and you said 1 to 4 years.
Yes.
What happens under the 1 year? You've not yet met the 1 year threshold.
So the commencement of the notice entitlement begins at the end of your probationary period. That period ends in 90 days. So if you are employed for less than 90 days, you may be terminated without any notice. Once you're employed for more than 90 and less than 4 years, you're entitled to 2 weeks.
So really and truly, in this scenario that Mercedes is in, AI has no bearing on the matter. It's the terms of the contract, really. AI or not. If it's another human or AI, that's not the issue here. It's the actual termination factor.
So the artificial intelligence issue creates another problem.
Yes.
So the terms of the contract inform on what she's entitled to, in addition to the terms of the legislation. So the legislation may say, based on her term of service, she's entitled to 2 weeks' notice.
Right.
Artificial intelligence in this scenario raises the question as to whether the company had a valid reason for termination, and that's separate from the notice point.
Gotcha.
You see, companies are allowed to terminate an employee once it meets one of the valid reasons in law. Either the employee has misconducted themselves, and it's been established through the relevant procedures. The employee has shown some poor performance, and that has also been tested and confirmed, or the employee is being made redundant.
That's where I was going, because in this situation, couldn't it be said that it's not that I'm terminating your employment, it's just that now the technology has moved us in a direction where this post is no longer of any moment, you know?
Absolutely. So that suggests that removing a post to replace the position with technology is in fact a valid ground for termination under the redundancy principles. You see, the redundancy principles require that the requirements of the business have been diminished or have ceased in such a way to make the employment in that role unnecessary. And we can say that that is satisfied in this situation. What seems to be missing from Mercedes' scenario is the due process that the company must follow. So to effect a redundancy redundancy, some consultation must take place between the company and the employee, and that she must receive an invitation to that consultation meeting, usually in writing. She should attend to make proposals to avoid a redundancy situation, and it is only after that meeting and that process is completed can they effect a termination.
Good to know.
I mean, is that fair to the employer, though, that they have to go through all of these hoops? They've paid good money to acquire this new fancy AI software. I mean, I have a right to take my business into the future. Why is it that I now have to go through all of these procedures to
because
do
the employees have rights too, no, sir?
Absolutely, and the law has been protectionary in relation to employees.
But not in relation to employers.
Well, they treat the employees as a more vulnerable group.
Right.
So the law has been designed in such a way to protect employees and to ensure that certain processes are followed before termination is
And
effected.
that's not anti-business in the anti-business by being pro-employee?
Well, many companies do think so. Many companies find that the labor laws in Jamaica discourage innovation and transition in smooth ways, and they require a lot of loops to be jumped through. But the reality is, if they're not, the company can get itself into some trouble. And the legislation is designed to protect the employee and to ensure that those loops are in place.
I guess the perception is that the employer has the handle and the employee has the blade.
Quite
so it has to be protected.
Yes.
I mean, I'm just saying that some people would say that we need an environment that's pro-economic growth and pro-people, business, innovation, etc. But I do get the impression that we come from a society that has tended to exploit the employee, and so that is how our jurisprudence has evolved in this particular direction.
Yes, well, certainly so. I would say a lot of our clients express the same sentiments, and we understand them clearly. And there are ways to optimize and to be effective in relation to the transition of employees. But at the moment, the law remains very employee-centered.
All right. Right on time.
All right, that was Jonathan Morgan, partner at DunnCox Attorneys at Law. On the other side of the break, we celebrate Earth Day. Sunrise continues after this.